A court may command a person to appear and speak, but sometimes appearance is not enough. The law may also require something more: records, documents, tangible proof. Not a request, a command. When the court compels not just testimony, but production, it does so through a device known as subpoena duces tecum. We examine how the law forces evidence into the open. I am Polemopicus, and that is the subject we now investigate.
Courts do not rely on voluntary cooperation alone. If a person or organization holds evidence relevant to a case, the legal system has a mechanism to require that evidence to be produced. That mechanism is called a subpoena. But not all subpoenas are the same. Some require a person to appear and testify. Others go further. They require the person to bring documents, records, or other tangible evidence with them. That type of subpoena is called a subpoena duces tecum. Understanding this tool is essential to understanding how courts obtain evidence from people who are not necessarily parties to the case. The phrase duces tecum is Latin. It translates roughly to, "You shall bring with you." A subpoena duces tecum is therefore a court order requiring a person to produce documents, provide records, deliver tangible evidence, or make materials available for inspection. This can be directed to a party in the case, a non-party witness, a business or institution, or a custodian of records. It is not optional. It is a legal command backed by the authority of the court. A standard subpoena typically requires a person to appear at a hearing and testify under oath. A subpoena duces tecum adds another requirement: bring specified materials. In some cases, the person may not even need to testify. They may simply be required to produce documents. For example, a bank may be ordered to produce financial records. A company may be required to provide internal communications, or a hospital may be required to produce medical records. The focus is on evidence, not testimony. One of the most important aspects of a subpoena duces tecum is that it can reach non-parties. This means you do not have to be involved in a lawsuit to be required to produce evidence. If you possess relevant information, the court can compel production. This is critical because key evidence is often held by third parties. Businesses, banks, and institutions frequently hold records central to disputes. Witnesses may possess documents that neither party controls. The subpoena ensures that relevant evidence does not remain outside the reach of the court. Although powerful, subpoenas are not unlimited. Courts impose important restrictions. Relevance. The materials requested must be relevant to the case. A subpoena cannot be used to demand unrelated personal or business records. Specificity. Requests must be reasonably specific. Broad, vague demands may be challenged. Burden. If compliance would impose an undue burden, the court may limit or modify the subpoena. For example, extremely large document requests, requests requiring excessive time or cost, or requests that disrupt normal business operations. Courts balance the need for evidence against the burden of producing it. Privilege. Certain materials are protected and do not need to be produced. These include attorney-client privileged communications, work product materials, and other legally protected information. Even under subpoena, privileged material generally remains protected. A recipient of a subpoena duces tecum is not without options. They may, object to the request, file a motion to quash, cancel the subpoena, or request that the court limit or modify it. Common grounds for challenge include irrelevance, overbreadth, undue burden, or privilege. The court then evaluates whether the subpoena is appropriate. If a subpoena is valid and not successfully challenged, compliance is required. Failure to comply can result in serious consequences, including contempt of court, monetary penalties, or orders compelling production. In extreme cases, the court can initiate enforcement actions. A subpoena is not a request. It is a command backed by judicial authority. Subpoenas duces tecum are closely tied to the discovery process. They are one of the primary tools used to obtain evidence from third parties, organizations, and individuals outside the litigation. While parties exchange information through discovery rules, subpoenas extend that reach beyond the parties themselves. This ensures that relevant evidence is not limited to what each side already controls. In real litigation, subpoenas duces tecum are used to obtain financial records, employment records, medical records, communications, and business documents. These materials often play a central role in establishing facts. In many cases, critical evidence comes not from the parties, but from third-party sources compelled through subpoenas. Several misconceptions arise around subpoenas. I'm not part of the case, so I don't have to comply. Incorrect. Non-parties can be required to produce evidence. A subpoena means everything must be turned over. Not necessarily. Requests can be challenged and limited. A subpoena overrides all protections. Incorrect. Privileges and legal protections still apply. Subpoenas duces tecum are essential to the functioning of the legal system. They ensure that relevant evidence can be obtained, third parties cannot withhold critical information, and courts have access to the materials needed to resolve disputes. Without this tool, important evidence could remain inaccessible. Cases could be decided on incomplete information. The system depends on the ability to compel production when necessary. The legal system is built on evidence, but evidence does not always come voluntarily. Subpoena duces tecum is the mechanism that bridges that gap. It allows courts to require the production of documents and materials essential to a case, even from those who are not directly involved. Justice depends not just on what is said in court, but on what can be produced to support it.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.